guys. I'm sorry this is so late. As you can hear, I'm just finally getting my voice back. But I wanted you to make some videos if you really wanted to watch them to make sure that you understand the concepts. So I'm going to try my best to give you some sort of a video this week to help you learn the different parts of the system. Okay, so we're going to go through that. So the first thing I wanted to show you was with the PowerPoint, I've also posted a chart. So you can see this chart. You can print it out and you can have it in your notes and you could write like your definitions in here. And it's a really good way to make sure that you know your steps. So you may want to print this out or have your computer open while you're listening to the video. And you can open the document and write it on it, type right on it if you want, and save it for your notes. But it's a really good way for you to see how the steps connect and to make sure you know the steps. So I wanted to make sure I pointed that out so that you knew that that was there. Okay. So what we're going to do this week is we're finally moving into the next part of the court system. So we talked about some general ideas last week when we talked about the different levels of courts and the different people that work in the court system. So this week, we're going to actually talk about the steps in the criminal justice system. So we're going to go through when a person's arrested all the way to the very end, possibly appeal, so that you understand what happens at each of the steps. Okay. So when you think about it, I want you to start with the concept, what happens before a person becomes part of the criminal justice system? So what has to occur before you even enter and start into the criminal justice system? How do you get in it in the first place? Well, you have to commit a crime. Okay. So before you even enter into the criminal justice system, you need to have a crime. Nobody goes into the system unless there's a crime. Okay. So, but now what I want to talk about is what happens to you after you commit that crime. Okay. So what is the steps that occur after you commit that crime? So the first step, so I kind of give you a little summary and you can think about what you think the name of the step is. So the first one is the police become involved, evidence is gathered, and police reports are written. Okay. So what do we call this when the police are gathering information, gathering evidence, and then they're going back and they're writing up reports? Well, this is called the investigation. So when somebody's arrested, and the police go out and they conduct an investigation. Okay. Now, once that investigation is completed, then they have all their evidence. We talked about in chapter 6, you gather all your evidence, you put all your blocks, and hopefully you get up to probable cause. Okay. So we want to have all that evidence. If we think we have probable cause, then we put it all together in a warrant. We go to the judge, we get the judge to sign the warrant. And then during this step, we actually go handcuff the person, read a Miranda, and take them into custody. So what do you think this is called? This is the arrest. Remember, we said arrest and custody are pretty interchangeable terms. Okay. So the next step, once they're arrested, you bring them back to the police station and you make an administrative record. So you fingerprint them, you photograph them, you get their personal information, you interrogate them, you can perform lineups, you inform them their rights, you may have them sign a form saying that you did in fact read them their rights. So what step do you think this would be? This is booking. Okay, so the booking is the process where you're making the administrative record. So all of these steps that we just went over, those are all things we kind of referenced when we talked about policing. So all of those kind of go back with the last exam, the steps in policing and what police are doing on a day-to-day basis. So pretty much from now to the end of this lecture, we're really going to talk more about what the courts do. So once we get through these initial police stages, there's many, many stages still in the criminal justice system that are dealing with the person at the court level. So those are the ones you probably really need to know, because you may not know those as well as you know the policing ones. Okay. So once the person is arrested and booked, then that defendant has to be brought in front of a judge. That judge is going to read the person their charges. They're going to tell them their rights again to make sure that they know their rights. They're going to advise them to get an attorney. And if they cannot afford one, this is where they'll start the process of actually appointing an attorney. And they'll determine if the person is entitled to pretrial release. So pretrial release is the idea of, can they get out of jail prior to the trial? Do they get to stay out in the public before the trial, or do they stay in jail? Okay, so all of these steps occur at the very beginning of the court process. And since it's the beginning or initial, we call it the initial or first appearance. Okay, so the whole idea of the initial and a first appearance is the idea that we want to make sure that people are in front of a judge as fast as possible to make sure that there's no police abuse, there's a proper arrest, you have probable cause. So we're going to have this initial or first appearance fairly quickly after the arrest to have checks on the system and make sure the person really should be there. Okay. Now, one of the things we said, and this one we kind of already talked about, is the idea of during this initial hearing, we have what's called pretrial releases. Pretrial releases is the idea of what is going to happen to you between the time of your arrest and the trial. Where are you going to go? What's going to happen to you? When you're talking about pretrial releases, there are 4 different choices. So number 1, I'm just going to put them in different order a little bit. You could be released on your own recognizance, and that's often called ROR. So if you hear people say, oh, they got ROR, that's what they mean. They're released on your own recognizance. That means the judge trusts them to come back later for the trial. There's no conditions, there's no money. We're just going to let you go and hope that you come back for trial. Okay, that's ROR. Sometimes they'll release you back to the public, but with conditions. You are released, but you have to stay away from certain people. You have to check in. So conditional releases, yes, you can go out back to the public before your trial, but you have to follow certain rules that the judge specifies. Sometimes if you're a juvenile, then they may give you what's called third-party custody. So they'll release the juvenile back to the parents, and then the parents are responsible to assure that that person will return later for trial. And then the last choice is bail. Okay, so, or you could have no bail, just let them go, which is basically release on your own recognizance, but you could also require some set level of bail. So all bail is you paying money to assure that you will show back up at trial. So that is all that bail is, making you put up some money, some collateral, something to assure that you will actually come back when you're supposed to come back. So bail is not a punishment. We're not allowed to use bail just to hold people in because we don't like them. We can only deny them bail if we think they're a flight risk or that they could harm other people. So those are the reasons for bail, not just because we want to hold them. So the judge has to make that determination, and the judge would have to also determine amount of bail. So amount of bail is often based on what we think is necessary to assure that you will come back. Okay, so if I put bail for $50 to a billionaire, they're not going to care that they lost $50. So that's not going to assure that they come back. So you can't just give somebody a $1 billion bail just because you don't want them to get out. You have to give them a reasonable amount of bail that there is a possibility that they could pay, and just assure that they wouldn't want to lose that money, and you want to make sure that they come back. Okay, so a lot of people think that people are only released on bail if it's a non-serious crime. But this chart just shows you between federal and state, the percentages of defendants that are released prior to trial, whether ROR or bail or whatever it is, based on the type of crime. So what's interesting is you can see that people on murder can still get out prior to trial. If they're not, maybe the murder was specific to one person, they're not a threat to others, or they are not a flight risk. Those are things that could possibly allow them to get out prior to trial. Okay, so that's the initial appearance. So you're arrested, booked, and we're taking you to a judge right away and having the judge do this preliminary check on you. But we still want to make sure that the charges that we're going to charge you with are proper charges. So what we do is we have another check on the system where we're going to have a group of 23 people review the evidence that the police and the prosecutors are presenting. And they will make sure or double check that the police actually do have probable cause so that the trial can continue. So this is sort of another check to make sure that there's enough evidence to go forward. Okay, so these 23 people, they meet in secret. Only the prosecutor shows what they have. There's no defendant there. It's one-sided. There's no cross-examination. The prosecutor just calls in witnesses and has them talk to these 23 people. And then those 23 people have to make a determination. Is there enough evidence to allow this process to continue? And this is called a grand jury. Now in New York, we only have grand juries for felonies. So if police are going to charge you with a misdemeanor, that's another procedure we'll talk about in a minute. But if we want to formally charge you, so we may have arrested you on a felony, but now this is going to determine the actual charges we're going to take all the way to court. So sometimes the police will arrest you to get you off the street for a more minor offense, but then they'll seek the grand jury to make sure that they have enough evidence to charge you with a different felony crime. And the grand jury is the one that's going to review that and make sure there's enough evidence to go forward. They're not determining guilt or anything, just whether there's enough evidence to continue on with the process. That's why the defendants don't have to be there. Okay. Now, if they review the evidence and they think that there is enough evidence to move forward to let the trial continue, then they're going to issue this document. So once they hear all the evidence, they have to determine whether or not they can move forward against you. And if they say, yes, there is enough evidence to move forward, they're going to take this document, this written accusation, and give it to the judge. And this is what we call the indictment. Okay. So if you are wanting to charge in New York a felony, you have to take your evidence to the grand jury and you have to convince them there's enough evidence to keep going. If the grand jury says, yes, there's enough evidence, then they issue the document called the indictment. And the indictment goes back to the judge and then the process can continue. Okay. Now, if they don't think that there's enough evidence to keep going, they can issue what's called a no true bill. So this is when the grand jury reviews everything that the prosecutor shows them and says, yeah, we don't see it. We don't think you're there. All your boxes don't get to probable cause. And so they issue a no true bill. That means the system stops. You cannot continue on to a trial if the grand jury issues a no true bill. So really it's the grand jury's prerogative to make a determination of whether or not there's enough evidence to keep going. Okay. Now we said that was for felonies. So what happens if it's a misdemeanor? A misdemeanor is a little different since it's a less serious crime with less serious consequences. We aren't going to require an indictment and a grand jury. We're going to let the prosecutor make the determination of whether or not they want to continue on. So if that's the case, the prosecutor reviews all of the evidence presented by the judge, and the prosecutor has to decide are they going to submit formal written accusations about this crime? If the prosecutor thinks there's enough probable cause to charge the misdemeanor, the prosecutor is going to issue what's called a prosecutorial information. So felonies go grand jury indictment, misdemeanors go to the prosecutor, and the prosecutor issues the prosecutorial information. Okay. Now, if it goes this route, if it's a misdemeanor, we still need a check on the prosecutor. We still need somebody to look at the prosecutor's choices and make sure that they're valid in the judicial system. So after the prosecutor issues the preliminary or the prosecutorial information, there has to be a little hearing in front of a judge. And the judge has to make the determination, is there really enough evidence to keep going on these misdemeanor charges? So they have a little hearing. The judge says, okay, yes, there is a crime. We have jurisdiction and there's probable cause. We'll let you continue. So that is what we call a preliminary hearing. So this is the check on the prosecutor's decision to continue on with the prosecution of a misdemeanor. Okay, so all these steps are just checks on the system to make sure that everybody along the system is doing what they're supposed to be doing. Now, if you decide that, yes, you can continue with these charges, then we have to bring the defendant in front of a judge and tell them now what these formal charges are. So the first time you came, your initial or first appearance, you were kind of told what the initial charges were. But then we've gone through steps since then, and the charges could have changed. So we need to bring the person back in and fill them in on what is the actual charges that they are facing at this point. So they are brought back in. The judge has to formally tell them now what the charges are, and they have to enter what we call a plea. So this all occurs during this step, the plea. Now, when you're talking about a plea, well, let's talk about the step first, okay? So what step is this called when you come in, told the formal charges, and then you plea? This is called your arraignment. Now, if you're super familiar with New York, sometimes they mix it up and they call that initial appearance the arraignment. It's just try to keep it straight in your head. Different states do things different, but just for now, for the purpose of learning, always think about the arraignment occurs when you're being formally charged. Now, we said that you have to enter a plea. There are different pleas that you can enter. So one of the pleas is guilty. If you enter plea, so they tell you the formal charges and you say guilty, then it ends. You just end right there and you jump to the very last stage, which is sentencing. Okay. But if you plead not guilty, then the system just continues on and you continue on with the criminal justice process. Now, there is a plea called nolo contendere. Nolo contendere is the idea that you say, okay, I am not going to admit that I did it, so I'm not going to plead guilty, but I don't want to go to trial, so I'm just going to let you punish me anyway. So nolo contendere is often called no contest. I'm not going to admit to anything, but I'm also not going to contest it. Some judges won't allow you to do that because they want you to take responsibility for what you did. There are some reasons sometimes where that might be necessary, but that's the idea of no contest or nolo contendere. And then you just skip to sentencing if you plead nolo contendere. So what about the levels of courts? What do you think? So the reason why I said this is because I want you to now connect New York. So we talked about the levels of courts, and we said if you're charged with a lower level crime, a misdemeanor, when we did levels of court, we said that your case would be brought to like the city, town, or village court. Okay. So if you are charged with those crimes and the ultimate decision for charging is a misdemeanor, then what court are you arraigned in for that misdemeanor charge? You're arraigned in city, town, or village court because they're the ones that are going to hear that case. But what happens if you're ultimately charged with a felony? We had said with the courts that if you're charged with a felony, you can only be charged at the county level. So the county level is where the arraignment has to occur. You can only be arraigned at the level of court that has jurisdiction. So misdemeanor, city, town, or village has jurisdiction. Felony is county court. So you have to be arraigned in the court that has the ability to hear the case. Okay, so this was just the answer. So these are where your arraignments will actually take place. Okay, now throughout this whole process, there could be something that's occurring. There could be a negotiation between the defendant, the prosecutor, and the courts. And that is that they agree on what the defendant could ultimately plead guilty to. Okay, so the defense attorneys, the prosecutors, they talk and they say, okay, prosecutor says, okay, I'll let you plead to this lower crime. And then the defendant say, okay, because it lowers the charge, may lower the sentence. So that is one of the steps that occur. And usually the court has to approve that. Sometimes they'll have them plead to the same crime, but the prosecutor will request a lesser sentence if the defendant pleads guilty. This whole process is called plea bargaining, when they have this negotiation and they try to reach a decision on what the charges should actually be. Just some information, 95% of cases are plea bargained. So most cases end in pleas, thank God, because our system is always already overrun, so busy that they would never be able to have all of the trials. So a lot of cases end in pleas. So there's a lot of pressure on prosecutors to reduce charges and offer lower charges because of the number of court cases and how much work they have and the ability to do that. So that's why you have a lot of cases ending in plea bargains. Now, just to fill in a couple of things about plea bargains, just so you have some general information. When you're talking about plea bargaining, there are some specific rules that have to be followed if you're going to plea bargain. So in the federal system, this is a federal rules. You have to inform the defendant of the rights that they have. So if you plea, you give up your right to appeal. And so you have to make sure that the defendant knows that if you plea, you can never go back to court and ask them to review it again. Okay. You have to determine if the plea is voluntary. So when the judge listens to the plea, they have to question the defendant and make sure that the defendant really understands and does this voluntarily, that the police or the prosecutor or the defense attorneys are not forcing them into this. The whole agreement has to be disclosed to the judge, so the judge understands everything that happened in that negotiation. And the the judge has to make sure that there's a factual basis for the plea. You're not supposed to allow defendants to plead guilty to crimes they didn't really commit. So the judge has a legal requirement to ask that defendant questions to assure that the defendant truly did commit that crime. Okay. Now, after that, so if you get through all of that and you get through all the stages, then the jury or the judge will actually listen to witnesses, listen to evidence, and actually make a determination if the person's not guilty. If they're not guilty, that means they are acquitted, or the judge or the jury could determine that they're guilty, which is a conviction. So what is the name of the stage where the attorneys present the evidence and the jury looks at the evidence and makes the determination of guilty or not guilty? That is the trial. Okay. So that is the actual criminal trial. Now I have at the bottom, I have what's called bench or jury trial. The defendant gets to make a determination what kind of trial they want. If they want a jury to make the determination, that's a jury trial. And the members of the jury actually make the determination if the person's guilty or not. If the judge makes the determination, the defendant can choose they don't want a jury. Maybe it's a high publicity case, or they think the jury is going to be swayed by something that isn't really true, then they can just ask the judge to make that determination. If the judge makes the determination of guilty or not guilty, that's what we call a bench trial. Now, if you go through the whole trial and the judge or the jury determines that the person's guilty and convicts the person, then you go to this stage, and this is the stage where the judge imposes a punishment on the person for the crime. And this is what we call sentencing. So this is when you pled guilty or nolo contendere, you skipped right to this phase. But if you found guilty at trial and you're convicted, that's when you go then to sentencing. The judge weighs the crime and the evidence and all the determinations. It's often guided by law, what the law says the punishment can be, and the judge will determine what the person's punishment or sanctions or sentence is. Now, sometimes when they impose a penalty, they can change their mind and take it back. Well, not take it back, but suspend it. So they can say, okay, we give you 5 years in jail. But they could say, well, but we don't think it's going to be productive to send you to jail. So instead, we're going to let you return to your home. And we're going to allow you to just remain under supervision. You're going to have to check in. We're going to have to watch over you. We may monitor you electronically, but you won't have to go to jail. This is what we call probation. So probation is when you are given a sentence, but they suspend it. And instead, they're going to let you be supervised in the community. Okay. But sometimes they don't. Sometimes they actually put you in jail and make you serve time in jail. That is what we call incarceration. Okay. So if they actually make you go to jail, that's incarceration. Now, sometimes you go to jail and they let you out early. And all that supervision you could have for probation, now you're going to do it after you've already served some time in jail. So you serve time in jail, we're going to let you out early. We're going to supervise you. That's what we call parole. Okay. So parole is when you're going to be let out early. Now, one of the final steps is, what if you think there was a mistake made during this whole process? What if you think that the courts did something wrong? They allowed evidence in, or they allowed somebody to testify that shouldn't, or they gave you too high of a sentence, or there really wasn't enough evidence to convict. Then you can do what's called an appeal. An appeal is when you go to a higher court and you ask the higher court to review what happened in the lower court and change their mind. So they're just going to look at everything that happened in the lower court and make a determination if there were errors. This is what we call an appeal. Again, this is a check on the court system. So you have one hearing or trial. We want to check or review to make sure there's no problems with that. So we have this appeal process. Okay. Now that you know all of your steps, I have a review assessment that you can do online. It's just a way to make sure you understand. These are basically terminology. So you have to make sure you understand all the terms, understand what the steps are, what occurs at each step. So this is a great way to review that and just to make sure that you understand what each step is. Okay. So hopefully you could hear me through all of this and that helps. And I will hopefully finish up with the other 2 videos later today. Thanks.